How's it going out there, Funk fans? It's Professor Phil. I'm back in your building. I promised a video, so here it is. What we're going to be talking about today is basically state or city, municipal, and county bonds. And as you can see here, this is the Missouri Municipal Guide. It's 2012. But Gilmore and Bell primarily is the bond counsel for most cities in the state of Missouri. As you can see, they service out of two different locations, but unilaterally they do most of the cities in general. Actually, I'm going to pull the website up too so you can get an idea of what that is. And this is their website: tax increments, industrial municipal revenue, neighborhood improvement districts, transportation development districts, schooling finance, sports venue financing, and economical. It just goes on and on. It's ridiculous. Okay. The bottom line is that when it comes down to the value of your finances, your municipal finance, that means that they are ultimately collateralizing your debt to increase their revenues. The prospect, and that is the municipality, the city, the county, or whatever interest of a constitutional level that grants them this jurisdiction, derives from a few spectrums of administering themselves into a charter and thus calling themselves a constitutional party, contractor, so to speak, to act on the benevolence of the people. All right. So, form of ballot. Now, this is one of the first moves that the city council will make in order to raise revenue. Okay. It's a shell and the name of the city, blah, blah, blah. Issue bonds in the amount of, in the dollar amount for the purpose of, and this is, of course, coming straight out of the Constitution. This, even though it's statutorial in its form, it's also in the constitutional, it's in the timetable of the Constitution. And these were prior revisions that were put in as well. And we're going to kind of skip through and get you an idea of exactly what you are in your definity of raising funds what would have to take place, even if you started an outside charter, a municipality of your own, and indulged a means of contracting surplus. Okay, so bonds issued when in terms, and this is, of course, going on from 95.150. Okay. Upon the results of the submission of the question being certified to the council, board of aldermen or trustees, and a trustee, remember this, can be incorporated for bonding opportunities. So that doesn't necessarily have to be the board of aldermen. It can just simply be certified by trustees within a company and then solicited to the city council for certification on the level of the city so that the board of aldermen can hear it. As the case may be, if the proposition to incur or increase such indebtedness be assented to by the constitutionality required percentage of the voters voting on the proposition, the council, board of aldermen, or trustee, as the case may be, may by ordinance or resolution declare the result of the submission of the question and cause bonds of such municipality to be issued, not exceeding the amount authorized in the denomination of not less than $100. When some multiple thereof, payable in not more than 20 years from the date they bearing interest from the date at the rate not exceeding the rate per annum authorized by law. All such bonds shall be signed by the mayor of the city or chairman and the board of trustees, or chairman of the board of trustees. of the town or village, as the case may be, attested by the signature of the clerk, and each bond shall have impressed thereon the corporate seal of the municipality. In the event the charter under which municipality may be operating makes no provision for the office of the mayor, such bond shall be signed by the presiding officer of the governing body of such municipality. That means if there's simply, in that last sentence, in the event the charter under which municipality may be operating makes no provision for the office of the mayor, meaning if he's not advised that he should be the authoritarian over the transaction, such bond shall be signed by the presiding officer of the governing body of such municipality. In other words, if he's either removed, he's not there, or the board itself decides it's passed the revision by majority, boom, it gets passed, and that's the end of that. In the event that the charter under which a municipality may be operating makes no provisions for the office of clerk, such bonds shall be attested by the officer designated by the charter as the custodian of the seal of the municipality. Now, I know I went through a bunch of stuff there, but that's part of some of the provisions if the bonds are issued, when, and the terms and conditions, and how they're presented, so to speak. Okay, this provision of section 5.115 to 95155 shall apply to all cities, towns, and villages of the state where organized by special charter or under the general laws of the state. Any provision of any special charter or city or village in the state to the contrary notwithstanding. All right. Treasurer or other officer to register bond when requested. All right. So it shows you the book entry, whenever the owner of a coupon bond or any bond payable to the bearer already issued hereinafter, issued by any municipal corporation now or thereafter existing in the state, where it breaks down where it has to be presented, what the duties are to register it, and all that good stuff. Now, remember, if you never voted for any of this is very important, is that as a voter, you did not vote for these bonds to be presented via, let's say, your property tax, or let's say the tax for cigarettes locally. Let's say it wasn't a tax on food. You didn't authorize that, but that's where they're presenting. And I'm going to actually pull that up here so that there is a better understanding as into what they actually can place these bonds against. Okay. And here it is right here. Okay. And this is very important because this breaks down where the money is coming from, where it's deriving from, so that they can turn around and make they can basically spoof the funds on principle of real estate taxes, city, county, and local taxes, any of these taxation brackets, along with tickets, municipal debts and municipal gains, fundraising mechanisms, especially when it comes down to how the city wants to raise its funds. This is how the levying of taxation goes. It's quite simple, and it's really directly in your face. The council shall have the power to levy annually taxes upon all taxable property within the city. That means if your house is in the city, you are being taxed to levy to pay for these bonds and its interest of indebtedness, in addition to other taxes, and in a significant amount for the purpose of paying the interest and coupons as they become due on all bonds now issued and outstanding. And such taxes shall be collected in the same manner and time as other taxes, even though they mean other taxes. It's consolidated. It means one and the same, in other words. The mayor and the city and the council also shall have power by ordinance to issue bonds payable in 1 year to an amount not to exceed half the current revenue for the fiscal year, and also issue, let's see here, lost track here. I'm sorry. Revenue. Okay. And also to issue bonds and renewal of other bonds of the city maturing, for the and which the city has no fund to pay, meaning that they can turn around with no money, turn around and furlough the new tax year into rolling over onto these old bonds, which basically just allows them to renew them entirely. Meaning we don't have to pay back the principal, even though we're paying the interest on it. We can't pay the principal back, so we borrow more against these levied amounts that make them readily available in the next fiscal year, which eventually is going to be borrowed against anyways because they're not going to pay that back, so it never gets paid. Okay, the investors just enticed by these ridiculous return policies ensure that in some way, shape, form, or fashion, if they got to up the tickets by, it went from 16.5% a quarter ago, it goes up to 80% because they need to re-revenue certain aspects of interest against bonds that they just borrowed against. So, boom, how do you pay it back? You wind up re-revenuing it by passing ordinances that are more stern to raise revenue, which again is fundraising tactics. Okay. Provided here, however, that such renewal bonds shall not bear any greater rate of interest than did the original bonds, meaning they're not going to go out. They're not going to go outstanding of the bonds because that would create a furthering of this of interest that they don't want to bear because they'd rather you pay the interest and they'll just hold on to the principal, and shall not run for a longer time than 10 years. The mayor and the council shall also have power by ordinance to issue bonds for the purpose of funding the floating indebtedness of the city existing at the time of its incorporation as a city of the third class, provided, however, that such bonds shall not draw any greater rate or interest than 6% per annum, payable subannually, and shall not run for longer than 10 years. Now, even though it didn't say anything about direct taxation, as you can see, this is funding outstanding debts. That means anything that's been levied that hasn't been paid on will increase and be payable at some later date, and that they have the revenue for it for the same purpose of levying any taxes that they have available at the time. That is, okay. Let's see here. We're actually going to go back and go to the form of bonds, okay? And I believe, yes, that was the last one that we were at. Yeah. Whenever under any statute of this state or charter of a municipal corporation, whether organized under special charter or not in the state, any bonds are issued, whether the proceedings of the issuance of such bonds have been had in whole or in part prior to the enactment of this statute, such bonds may be issued either in the form of coupon bonds or in the form of registered bonds, or some form of coupon bonds and some in the form of registered bonds, as has been or hereafter may be provided in proceedings of the issuance of such bonds, and notwithstanding any language or provision contrary contained in any statute or charter authorizing the issuance of bonds or any other law of the state. The provision of this section shall apply to the coupon bonds as issued, as well as other coupon bonds and other bonds payable to the bearer. Okay, and the bearer is your investors that basically pour in ridiculous amounts of money to relieve the funds of the processing of statutes that are yet to be collected on, which is future contracts. So these statutes are passed, these ordinances are passed to fundraise, to pay back the interest and to solicit the benefits of those contracts on the premises that they're paying back the fixed amount of interest, and then are going to renew those bonds for other purposes such as building infrastructure, schools, private charters. Now they're beginning to take money out of the block fund, and the block funds are, let's look them up very quick. Them old block funds. Let's look those up. And those are, school fund. I'm sorry. Yeah, Was that might be it. This might be it. Hold on just a minute. We're going to look at it. Block funds is commercial estate funds sponsoring, specialized in creating wealth for our investors through and sound investment management. We target institutional grade assets with strong returns, deliver optical cash flows, favorable financing terms, and solid appreciation for clients. Let's see in their portfolio. Let's see if they have any. Actually, let's look at their acquisitions and see what targeted markets they're after. And this is the reason why when you're looking at marketplaces, you're looking at the way not just merging markets, but markets on financial provisions are based on sinking funds, for instance, and block funds are given to the state to grant opportunities for investors to solicit growth in a sector in which the private companies simply want access to capital, and to herd that capital and to ensure that they can keep their rates low by keeping those in competition for those jobs and opportunity at an all-time low, so that their competition on the basis of productivity is at an all-time high. That means that you employ the least amount of people but get the most productivity from them. So, this goes into something completely different, but it has everything to do with, if we don't make change, so to speak, then the financing opportunities dries up because you're not producing fast enough. Thus, you can do the job of 5 people. This is exactly what it's all about at the end of the day. Now, I'm even though I went to a website I thought might have something to do with it, I'm going to go and put state in there and see if it pops up. Maybe that'll, yeah, there we go. Community development block grants. This is for like housing. This is for schools. This is for water and sewage. You name it. It has something to do with it in some way, shape, form, or fashion. Eligible applicants, which is the very thing you need to look at very closely. State CDBG funds are only available to non-entitlement areas. That means that people that are raising enough capital and taxable revenues are not going to be suitable for this particular program. This is suitable for poor people and those in which do not use the surplus for the maximum return of self-sufficiency, which is basically self-governancy. And in order to do that, you are looking at the fact that the purpose of this program is to train and operate a municipality as a corporation on one principle, making you think that you need them more than they need you, which keeps the critical people that want those opportunities out of those opportunities by oppressing them with the mechanism of the funds to be put into other disenfranchising entities that disenfranchise the very people it's supposed to be authorized to be used for. I know that makes no sense, but when you look at the program, it makes absolute sense. I mean, you think about the type of money and the growth and development that they're supposed to be putting into these poor people, and then the application slips the routing of funding, and it winds up in the hands of those that wind up misappropriating it for the same purpose of tax revenuing. Its ultimate goal, which is to raise revenue from people that don't have any revenue. So you would ask yourself, why would anyone give money to a non-for-profit that runs like a corporation and then runs like an entitlement program? It's entitled to all these funds to be returned to it, but yet and still, it doesn't use any of those entitled programs' monies to develop the improvement, as it says here. It says right here, and this of course goes to schools, it goes to city managers, it goes to mayors, it goes to the city council members. All these people get this funding, and this is what it's supposed to do: improve local facilities, address critical health and safety concerns, and develop a greater capacity for growth. We offer funds for projects that can range from housing and street repairs to industrial loans and job training. So this chunk of money that they're authorized to use is basically really a means of the authoritarians to misappropriate it and put it into programs that are more based on fundraising than actual use like for instance, let's say let's look at the wordplay here. Safety concerns. Safety concerns is, the community has a outreach programs, but these outreach programs were depleted on the principle that people were doing something that the government was not sufficient in operating under, so they destroyed those infrastructures and those safety concerns, havens placed in part by people that were basically employing themselves to take care of their own neighborhoods, depleted in not only their resources, but conspiratorially taken down for the very concern of creating safety concerns for the purpose of funding, which is to say we need more police instead of more advocates that can do the business in which the neighborhood would present their claim to say we can do it ourselves, which means you don't need any safety concerns by law enforcement because the basis of your concerns are self-sufficiency, in which outside and supposed improvement programs come through to emphasize its plans to help you, when in reality it has no capacity for the next thing, developing the greater capacity for growth. Now, if you're a minority, as they call you, and they're claiming that you have money in the principle of fundraising, but yet and still they had the funds to ensure that your program and your operation for self-sufficiency works, then the develop a greater capacity for growth would mean that they would have helped you from the very beginning to grow, instead of putting these funds into other diminishing programs that ultimately ciphered off the way the city has to operate on your behalf, which then authorizes them to do this. All of a sudden, they come through with their Housing and Community Development Act of 1974, which is amended as a pass-through funding program from the United States Department of Housing and Urban Development. So that means the feds are now giving, through the United States Department of Housing and Urban Development, to the Community Development Block Grant, which is a huge chunk of change. You're talking almost probably trillions in one municipality to be handed this kind of money to take care of locals, of populations, as they say here, incorporated municipalities of under 50,000 and counties under 200,000 in population. Okay, and then you got your funding limits and its maximum minimums, and then the application approval, okay, of this entitlement program that's given to the city to operate on, to give you housing and pass through their accounts this community development block grant, which usually enters, usually it's to emphasize we need more school dollars. That's usually the catch, unless they're talking about homelessness or the debt to income ratio has taken a turn for the worse, and we need more funding for other particular projects that emphasize those particulars, especially when it comes down to school, housing, and certain developments in areas where the principal funding is lacking. So this is very important how this whole demonstration is used, and how now they're even deferring some of these monies. Let's look up. I saw a story, I think it was yesterday, and they cut almost $10 billion in schooling aid. And this is it right here. Says here, legislative leaders unveiled plan to fund Kansas schools with block grants. But you know what? When they turn around and do this, what they do is they do something very, I guess you can say, I'm not going to say cutthroatish, but something that kind of caused legal brute force, so to speak, in reducing what they were going to get. I'm trying to find it here. And state this refunding the same we think. Best case scenario. The classroom might be funding Kansas facing. Okay. $600 million budget deficit for the fiscal year beginning July 1st. That comes after the legislature passed deep income tax cuts. Here we go right here. Okay. In 2012 and again 2013 at Brownback's urging. lawmakers have been studying options for raising taxes. Now, you think of it for a second. You're talking about urbanizing the royalties and the financial underwritings of this huge amount of money that the legislator are telling the federal government we need block grant money. Now, remember, this is free money. This isn't money that they pay taxes on. This is money that comes from the taxpayer's pocket to reimburse the federal government for what it is providing. So let's see here. We're going to go and we're going to talk about this concept that has to break down between what we have learned here, I guess, and what eventually is going to be, I guess you could say, the premises of them asking for more money and why it has to come from your pocket. And so now when we're looking at Kansas City, for instance, and it's facing this $600 million deficit, what I actually had found, which was, it's startling in the numbers that they're talking about. It says preliminary data showed that the interim funding plan would dump total state spending for public schools to more than $4.2 billion for the 2016-2017 school year. That's roughly $333 million, or 9% more than what was allocated for 2013-2014. However, those numbers were still being refined late. Was that late? Late Thursday. Now, the funny thing about this whole thing is how they winded up reducing the deficit by like 10, I think it's like close to $10 billion. It was chopped up. Now, I saw the original one, which is kind of funny, but I can't seem to find it now. And as you can see, this is part of their plan of raising taxes. Lawmakers have been studying options for raising taxes, including higher levies on cigarettes and alcohol. They also consider changing the way taxes are assessed on farmland, gas, gasoline, and sales and passive income, which include rent and royalties. So essentially, they're trying to see that people that are capitalistic are getting cuts, while the people that are not making any money and use most of the luxuries of liability, like cigarettes and alcohol, not only tolls on the body, but the premises of creating any type of commercial realty of any kind will be depressed based on that tax furlough that they want to stick on the balance sheet. And then, of course, the last of the sentences of all this entire this envisioned and brazen tactic that these lobbyists want to pull is that this is obviously, he said, one half of the balance sheet, which is how we can basically ensure that people that don't have any money, that don't raise any funds, and more importantly, don't care to be installed into this infrastructure for balancing the budget, that will be basically those in which will lose out on the primary focus of raising funds. Okay. And if we're raising funds for you that don't do anything, that don't provide for yourselves, that don't produce commercial means of producing producing tax dollars, and most importantly, producing revenue, well, you just take the back seat, and we'll try to figure out how to identify the problem by increasing taxes where we know that you primarily focus your money at. If it's alcohol, cigarettes, things of this nature, well, then you're part of that group, and you know exactly who I'm talking about. We don't have to distinct you by whom we're taxing. We distinct it by the statistics of whom will be taxed for those particular products or services. Whereas, again, if we reiterate where they're actually reconsidering, they actually mean reconsider. They also mean reconsider changing the way taxes are assessed on farmland, gasoline, and sales and passive income, which includes rent and royalties. So essentially, they're not aiming at commercial people with real money that actually are part of the middle class. They're aiming at people that don't really have any money, which distinctively are based on the statistics. They don't make a lot of money. They don't produce commercialism to the point where commercial dollars, which end up in taxpayer furloughs and tax increases, of course, then tax write-offs, who then prosper from the benefits of those that do not have the tax resume to produce income, to produce self-sufficient finance and things of this nature, are just simply left behind. All right, let's go back to the bond assessment here, which are bonds that are negotiable. All bonds purporting to be issued by virtue or in pursuance of section, these particular sections, as you can read them, and signed and sealed as herein provided, shall in favor of a bona fide holders. And by the way, if you happen to be listening to this, you can always stop it, rewind it, start all over again. I know I'm moving a bit fast, but I'm trying to get this done as quickly as possible. All right. Be conclusively presumed to have been duly and regularly authorized and issued in accordance with the provisions hereon contained, and no holder shall be obliged to see the existence of the purpose of the issue, which basically means that you don't necessarily have the right, or neither are you obliged to see the existence of the purpose of your taxation being paid into these bonds that are negotiable, or to the regularity of any of the proceedings or the validity of the judgment or decrees to be paid, meaning when the city has to, it falls into my brain literally froze. If the city is, or the municipality is, or the county or whatever is presenting the claim of paying a judgment, they can raise funds against that bond. They can sell that bond to the person in which would be granted the judgment, and then the decree that would be paid is something from the regularity of the proceeds that are made from tax furloughs and things of this nature, or the application of the proceeds. All such bonds shall be negotiated or negotiable in respects to the same extent as securities negotiated by law merchants. That means people that basically negotiate bonds on the premises of banking transaction, credit contracts, and things of this nature. That's about the same thing you're looking at. You're talking about a financial administration for and its indebtedness based on statutory ordinances, laws, and things of this nature. You can even raise funds off of other tax furloughs on the premises of getting a contract, and then using those tax furloughs to raise money on the premises of a particular type of transitioning transaction that ensures that you can join the quote-unquote commercial world, which is exactly what this is all about. This is the reason why the last sentence pretty much says we're a corporation negotiating bonds on the same extent as securities negotiated by law merchants, which are bankers, institutionalists, and financiers. Okay. Bonds not to be registered with the auditor. No bonds issued under this provision. Now remember, when you're issuing a provision in which this statute would apply, they do not have to be registered with the state auditor. This provision shall be required to be presented to the state auditor or registered by him, nor shall any of the provisions in the respective issuance thereof be required to examine or certify by him or other persons or officers, except shall be provided by the city council. Meaning city council basically can have anybody come up with a private presentment. They then can walk around the issuance of registering the state audit, registering your bond with the state audit to finance your situation or circumstances. All right. Now remember, at the bottom, they're all revisions of the statutes that they're using. May issue for certain purposes. The city council of any city of a third class may provide for the purchase of ground and the erection of the city halls, fire stations, assembly halls, memorial halls, convention halls, public library, hospital buildings, equipment and other buildings, and the improvement thereof, and payment for the same, and also all necessary work improvements specified in Chapter 88 by the issuance of bonds or otherwise subjected to the conditions and limitations provided by section, and yada yada yada. We go. All right, bond and debt, we already been there. And what we're going to be looking at is school bonds, loans, and things of this nature with the city depository. Boards of aldermen in cities of the fourth class at their regular meetings in the months of January, April, July, and October of each year may select a depository to the funds for the funds of their respective cities for the length of time and under the rules and regulations that are provided prescribed by ordinance thereof. The rights and the duties of parties in depository contract are as provided in section 110.010. The deposit shall be secured by by deposit of securities as provided in that particular section again, and another section that's provided. Well, we're gonna 110.020. The depository shall be a banking institution doing business within the city. If such depository cannot select or such satisfactory arrangements made, the boards of aldermen may invest the monies upon the terms and under the conditions provided by law for the loaning of county and schools monies. Okay, so that has everything to do with your pockets. Everything to do with your pockets. Collector of settlement monthly with the treasury. It shall be the duty of the city collector to pay into the treasury monthly all monies received by him, all sources which may be levied by law or ordinance. Again, these fundraising tactics to otherwise say this is the reason why we need your money. We need your money to raise for funds, to allocate and contract your funds to refund and pay back these particular, not the law or the ordinance, but these investors on the premises of what they've borrowed, to ensure that what you're paying for is based on what we have provided you under law ordinance when it comes down to the fundraising mechanism. Well, the fundraising mechanism of the law, which is to otherwise create a budget saying how much we have in the budget, how much is in the surplus, and how much we're going to use, as if you have donated or otherwise given your money under law and ordinance. You know, you broke a law, you solicited a law enforcement, you did something that came about in which you had to go to a law enforcement center, or as they call it, the courthouse, to pay a particular debt, in which reduces the ordinance to zero and increases the probability of that happening on a continuous basis. The basis of that is not only your ignorance, but the forced reality that you are being taxed for that particular purpose. Okay. Also, all licenses of every description authorized by law to be collected and all monies. Now remember, also, all licenses of every description authorized by law to be collected. That means that when you're going in to get a state ID, that's money collected for taxable purposes. You want to get a CDL. If it goes through the state, it's going to be taxable, collected on whatever ordinance or law that they're providing. And that is whatever law they're saying that they're raising that fund for. And all monies belonging to the city and may come into his hands. He shall give such bond and perform such duties as required by him by ordinance, and that's the city collector. All right. Now let's see here. I'll just read this for the sake of argument. No money shall be paid out of the treasury except on a warrant signed by the mayor and attested by the city clerk. So, for the most part, any money that's supposed to be signed over to anybody has to be on warrant. All right. No warrant shall be drawn upon the treasury, nor shall any ordinance appropriating money be passed unless there is an unexpended balance to the credit of the city in the fund of the treasury upon which the warrant is drawn, to meet such warrant, or sufficient sum of appropriated money in the fund in the treasury upon which such ordinance is drawn to meet such ordinance. So if you have violated one ordinance and you have paid into one ordinance, those monies that are available, that are sufficient to be the sum unappropriated, meaning that it has never been appropriated for a particular purpose, you can then siphon off that fund onto a new ordinance, which of course is that's the benefactor of being able to contract. You can contract one ordinance against the other, and whichever one has sufficient funds would pay the other, zeroing out both back. balances. But also, this is the basis of contracting primarily the ordinance that in which funds have been appropriated but are not being used or are on account. So that means if you call the treasury and you said, hey, how much do you have on this particular ordinance? And they say, oh, we got $250 and you owe $90 on a city ordinance violation. Voila. Guess what you got? Now you have something where a warrant could be issued, attesting by the city clerk, underwritten by the mayor on the premises that particular law, and that is if somebody paid on it. So if I paid on, I don't know, a city water bill, and you know, that you wind up saying, well, I owe $80. They say that under water and sewage they got $250. If you sign your contract over to me, I can go to the state treasury and tell attest that the mayor under this particular statute would have to transfer the fund because it's been unappropriated only on the premises of the Water and Sewage Act or Water and Sewage Ordinance on the premises that I'm signing the bill over to you. Sophisticated, a bit above and beyond most pretentious people to understand the simplicity of it, but the contractual concept is no less than me giving my money to Walmart and Walmart giving you my money in redemption of continuing to tax me for a particular purpose, which would ensure, schools, ordinance violations and things of this nature would be paid with money that would be sufficient in the circle of those in which indulge contracting the unappropriated sums of money that the Treasury is withholding and acting as if they only use it primarily for the city's purposes, which it rarely does. It simply puts it into investors' hands and it gets lost in translation for money that they borrowed on bonds that have been allocated for the same purpose of raising the fund, which is to take your money. Every bill that contemplates the payment of money shall, upon its second reading, be referred to the Treasury or the person acting as Treasury for its endorsement to the effect the sufficient sum stands to the credit of the city unappropriated in the fund covered by the ordinance to meet the requirements of such bill. So every bill that they pass, and I'm gonna cipher this off for you so you can understand what I'm talking about. Every bill that contemplates the payment of money shall, upon its second reading, be referred to the Treasury or a person acting as a Treasury. That's you acting as a Treasury for his endorsement. That's you for your signature to the effect that a significant sum stands to the credit of the city. So that means when they give you an ordinance violation and you sign the bill, that's as good as saying that to the effect that a significant sum stands to the credit of the city. Means that they've already credited their account as unappropriated, meaning monies that has not been drawn out of your pocket yet, in the fund covered by such ordinance to meet the requirements of such bill. So that means that they have to have matching funds before they can even make you pay a bill. So if it's unappropriated, but yet still they're holding appropriated money to fund to cover such ordinance to meet requirements of such bill, it means that they have a prepaid sum of money to say that we match what you have, and unless you transfer the fund to another interest in which an ordinance can be paid, that bill is unappropriated, meaning it has not been paid, and the warrant has been withheld in your name. And if it's withheld and you haven't paid it, then they set the warrant in the amount in which you have not paid, thus a debt warrant or a warrant for your arrest. It's about the same thing, it's the equivalent. The Treasury shall report to the Board of Aldermen on or before the first day of July in each year the amount of the receipts and expenditures of the Treasury, the amount of money on hand, and the amount of bonds failing due, if any, for the redemption in which provisions must be made. That means that they have to be in whole or in part redeemable by either redeeming your body or redeeming your property. This way that they can pay their quote-unquote debt. Also, the amount of interest to be paid during the next fiscal year, which is fundraising on the mechanism of showing that if their balance is redeemed, then they can get more money in the next fiscal year based on what they're going to borrow. That is, if they're able to pay all their interest off from all the money that they've ciphered off on principal. he shall also perform such other duties in the line of his office as may be required by him by ordinance. The report of the Treasury may be published if deemed necessary by the Board of Aldermen. It's funny, they can just do it when they want to, in other words. Bonds may be issued to pay judgments when and procedures. Now, here's the great part about someone that I'm speaking to here in North Carolina that I want to do this with, which you can take the taxpayers and basically say, hey, sign this particular ordinance. Well, the law prescribed by the principle of paying a particular debt, using a bond to allocate all the signatures for the primary purpose of raising the funds from the taxpayers instead of going directly to the city, suing the city, attesting the city violated your rights or your benefits or any of the laws that would violate the contractual obligation to uphold the same. In other words, like the Constitution and things of this nature. And anything that's attested outside of it would be required by statutory premises. And of course, if you get them bound by it, they'll just raise the fund off of a bond and then tax everybody for enjoying the benefit of the bond being paid out to that individual on the premises of the city being liable for what it can gain. It only can gainfully abstract out of contract and pay out, in which the taxpayer then have to be furloughed into the judgment therein, paying the debt in which the state, city, or municipality has to pay out, while at the same time, privately, these agencies still continue to pay out on gainful guarantees for jobs and services. They continue to pay people furlough while they're off the clock, and of course they never have to pay for anything on the premises that the taxpayer will be asserted as the constitutional pledger of those debts and obligations in which the city would raise funds from. The same bonds in which would authorize them by the Constitution, and the liability which will roll over onto you, which we will discuss about our friends here, Gilmore and Bell, about how they raise all their funds and how we wind up in the entity's bubble. As you can see here, they're sitting on, this is what they're saying, that in the aggregated sum, they have been able to, the firm delivered the approving opinion on a 420 long-term municipal issued aggregating $6,856 million in principal amount. That's just the principal, not even interest. Okay, and that's probably one city. Just one city. Okay, I just really want you to just be silent for a moment and say, wow, that's a lot of money. And I mean, that's a lot of money, okay? All right, now we're gonna go into the process and procedure of paying judgments. The mayor and board of aldermen of any city of a fourth class, upon the assent of the constitutional required percentage of voters of the city voting on the question, may by ordinance issue bonds of the city amounts not less than $100 for the purpose of paying any indebtedness of such city, reducing to judgment, which bond shall run for a period not exceeding 20 years, may carry interest at the rate not exceeding the rate per annum authorized by law, which shall be signed by the mayor and attested by the city clerk, and shall bear the seal of the city. Now, the thing is anytime, and if you've ever noticed, if the city's ever fallen on, a hate crime, or someone getting really beaten, or someone getting their property taken, and the city has to pay for it, you've never seen the fact that the city would turn around and say, hey, voters, I have a question. Do you think we can just pay the judgment with a bond? Absolutely not. So this right here is a statutory provision that really should really bubble the nerves of any good person that realizes, the deck is stacked against me on the premises that I'm paying something that I didn't attest to and neither did I agree to. Okay, indebtedness of the city is just like paying taxes on your property. You never agreed to it. You don't have a direct contract with the city saying I'm going to pay taxes. The city just says, hey, you got to pay taxes simply because it says so in the law. That's it. And of course, the law is unsigned because they need you to sign an ordinance in order for them to what? fundraise on the premises that they have appropriated funds, in which they say they have unappropriated, but yet still they hold those funds on the premises of reinvesting with the principal holder of their debts in which they have borrowed against, which is us. So, in reverse, it really doesn't look right. But on what we're looking at from basically a screen, it makes all the more sense on the principle alone, which is whom is borrowing it and why do we have to pay something they're borrowing, okay? Indebtedness of a city not to be increased proceeds from sale bond how applied. No bonds shall be issued in such manner as to increase the indebtedness of said city, but such bonds shall be sold as directed by the board of aldermen of such city, and the proceeds thereof shall be applied only to the payment and the discharge of the judgment and decrees of any court for the payment in which the same may be issued, and such bonds so sold shall be delivered at the same time that the judgment and decrees aforesaid shall be paid and discharged, meaning that by the time they wind up with somebody that they have to pay out, they've already discussed how much money they'll be able to pay out and the premises of that payment. Okay. Tax to be levied for bonds and interest. Now, here's where it gets relatively interesting. Every city issuing bonds under the provisions of this section, 95.370 to 95.400, shall before or at the time of doing so provide for the levy and collections of any annual tax sufficient to pay the interest of such indebtedness as it falls due, and also to constitute a sinking fund for the payment of the principal thereof within 20 years from the date of issuance of said bonds. Now, the reason why they do it between the 1st and the 15th when they're coming after you is because when it's just like paying income. The more people they capture on the 1st and the 15th is how much in interest they're going to have to pay back to the bondholders, because they're looking for their income as well. So that's kind of why they catch you doing it in the act, and then of course levy you for using an ordinance in commerce. Okay, for the purpose of testing the sense of voters upon the proposition of issuance of bonds and tax levy provided for this section, the mayor and board of aldermen of such city shall order the question to be submitted to the voters of the city. That usually is not the case. So we're going to go over, indebtedness. Let's see if I can close in here. I'm not sure if I can. Let's see. Zoom in. That's a little bit, and then the plus. Okay, so we figured this out. We're gonna close in just a little bit and get a closer look at what I'm reading here. Okay. All right. And is this? I think that's it. So, all right. Indebtedness for waterworks and electric. I may have to back it up just a little bit. It's not going to open entirely. Okay, there we go. Any city, whether organized under the general laws of this state, or by special charter, or by constitutional charter, by vote of the constitutional required percentage of the voters thereof voting thereon, may incur any indebtedness in the amount not to exceed an additional 10% of the value of the taxable tangible property therein, as shown by the last complete assessment for the state and the county purposes, for the purpose of paying all or in any part of the cost purchasing or constructing waterworks, electricity, or light plants to be owned exclusively by the city. The total general obligation indebtedness of such city shall not exceed 20% of the assessed valuation of such city, as shown by the last complete assessment for the state and county purposes. So this means right here, as you can see, this is where your statutory recommendation via the state ordinance laws and as you can see here, the Missouri Joint Committee on Legislation, that the statutory premises of law as you can see, it clearly states that they are raising revenue for that particular purpose. So, we're going to get off into Gilmore here in just a moment, Gilmore and Bell, and break down the constitutional finance and, of course, the objective preliminary breakdown on what we simply have slipped the bar on understanding when it comes down to the financing institutionalism of their institutional means for gainful representation and debt allocation for using bonds and representing us under this constitutional referendum the state calls control. Now down to the financial government purposes and projects for the mandate of these particular bonds, which are passed off by Gilmore and Bell for the Missouri's Financial Guide of April 2012, but for the stipulational purpose for the budget and its gainful financial demonstration. All right, let's read it together here. Okay, financial government projects. Okay, and this means municipal, city, county, all these, state, federal, you name it. They're all in on it to ultimately create the complexities of what we today know as this revenue driven entity. We really don't want to give any money to, because we know the type of things that it does, what we're up against, what it will be used for. And ultimately, even though we don't know all of what they're using it for, ultimately it is the bottom line to keep people socially, economically, culturally, and socially oppressed to a certain extent. And I'm talking people even in the middle class that find that relatively scanty tax codes make for a healthy regimen for an entity that doesn't seem to go bankrupt, it doesn't seem to go under, and it definitely does not seem to find somewhere to go other than in your pocket. All right, so let's read this together. As federal and state regulations become more complex and financial resources needed to fund governmental operations become more scarce. Now, it's funny, scarcity with statutorial codes, internet locations, ink that doesn't seem to run out, and paper that seems to just run by the mills of just banana amounts of resources to otherwise put this type of information together. Its scarcity is hilarious, okay, at best. The 21st century brings a significant challenge to the municipal finance officer of Missouri, and that means anybody that receives benefits from the state, period. In order to balance the budget, now you see it teeters on quotating balance, okay? And the balance means let's do the act of providing what looks like the balance with sufficient accountability on the idea that that's what we emphasize to do with the budget. We're trying to do you a favor by making it look like it could be done with no emotion, but with a tedious strike of the pen, we can make it look good on paper. Yet and still, their scarcity is based on balancing an idea, but yet and still balancing the course of us renaissancing into a natural effect, so that these type of things are unnecessary, causes these people to believe that there's no other way to do it other than the way they see fit. Okay, the finance officer will need to utilize many funding sources. One of those sources are the ability to finance capital improvement projects. Prudently, this financial management tool can allow a municipality to construct needed infrastructure improvements while at the same time funding needed administrative, cultural, and social programs from current revenues. This presentation is needed to as a summary of significant financing tools available to Missouri municipal finance officers. It is not intended to be exhaustive. Specific questions concerning the financing options discussed herein or other methods may be addressed to any member of the firm. Okay, and the firm that is Gilmore and Bell. Okay, general obligation bonds. Missouri municipalities are authorized to issue general obligation bonds pursuant to Article 5? No, 6, Section 26B, C, D, and E of the Missouri Constitution, and Section 95.115 to 95.130, which is the revised Missouri codes. All right. Or statutes. General obligation bonds are secured by the full faith and credit and the taxing power of the municipality. Now, we already know what full faith and credit is. Well, I'll actually pull it up so it doesn't stun you that they're basically using the idea of what would be considered codification, but it's not. It's constitutional power. Article 5. Sorry, that's 5, 6. No, that would be. Actually, that would be 4. I'm sorry. Was it takeaway? Wow. Okay, I'm having a bad day here. Article 6 I'm looking at here, and that seemed to be the opposite. So that's, wow. Yes, 6. This would be Article, oh boy, my Roman numerals is off today. It can't be Article 4, is it? I'm having a really tough time here. Article 4. Wow, yeah. What a day. Article 4, Section 1 of the United States Constitution, known as the Full Faith and Credit Clause, addresses the duties that states within the United States have to respect the public acts, records, and judicial proceedings of every other state. So that basically means that the United States has to respect when a state wants to raise funds, use the full faith and credit clause to otherwise specify that the public records are forms of deposits. So like your mortgage claim is a deposit for taxation purposes, is to otherwise raise funds, is a fundraising mechanism. And of course, if there's full faith and credit following after it, it says taxing power of the municipality. So it consolidates both one and the same, but the only reason why they're separate is because full faith and credit is something that you borrow. Taxing power is something that you lay claim to until taxation has been done, and the unappropriated funds are then restrained and otherwise deposited and then used for the purpose of paying these investors back, which is the primary purpose of the investment, is to pay the interest on money that they have gainfully claimed or laid claim to and are saying that is what they owe. So, go back into the sentence. Let's see here. This means that a court can compel the municipality to increase property taxes if needed to repay the bonds. Very interesting. Again, this is Gilmore and Bell saying that revenues based on the constitutional ramifications and the statutory ramifications of gainfully taxing property is the basis of increasing not only the tax furloughs themselves, but increasing it for soliciting principal based on interest payments that they have to make, and that if they come to a shortfall, someone has to pick up the tab, and that is you, the taxpayer. The owner of a general obligation bond may look for repayment to all legal available sources of revenue that the municipality is entitled to receive. Now, remember, this is a non-entitlement means to raise money through, say, the community, through a federal grant, and the federal grant provides these funds under, say, the community development block grant, and yet and still you pay taxes on that, where there said there be no entitlement, but yet and still they have to raise money for your schools. That's very interesting. So that must be either an excuse for paying municipal bonds back that they're borrowing and access to, in which their marketable campaign is based on your taxes, or whether or not it's on real property or unintangible revenue or revenue stream commercial products such as cigarettes, alcohol, gas, things of this nature. But they are entitled to receive the basis of taxation, but the payroll that raises these revenues to create the entitlement clause is to otherwise separate non-commercial entities and commercial entities, but yet and still the non-for-profit they call the city of Kansas, the Kansas City, for instance, or St. Louis, act like entitled corporations, which in more cases like St. Louis has a tax identification number. More than likely every other city and most cities, if they're incorporated looking to raise funds, are more than likely incorporated for that particular purpose. We looked at it at the first section, the first juncture of the grant blocks. The block grants, which specified that it has to be an incorporated municipality, which has 50,000, under 50,000 in counties, and which had under 200,000 in its population. So it's kind of like saying that this minority community development grant block or block grant is for minority programs that have less than 50,000 in a municipality, or in a county has to be less than 200,000. Okay, so more than likely, if you're in very small groups in which they have sectioned off and they've redistricted your area, the basis of that district is that district is a municipality in and of itself, given its own jurisdiction, given its own powers and things of this nature. And counties with over 200,000 usually are people that are not in poverty-stricken areas, and if they are large populations, gainfully on the toll of registered voters and not population alone. And that's another reason why, if you're looking at the tax rolls and you have 500,000 people annually that live on a particular side of town, but there's only 200,000 that are registered to vote, then that is what you're looking at. You're looking at the equivalent of something that is places a disposition to expand in a county based on districting a particular portion of town or a particular portion of a city for funding resources, and otherwise allocating the pockets of the state where revenue may fall short, and general obligations can be re-revenued through other sources of entitlements that will be gainful on how those programs are set up. All right, so you might be poor for a reason is what I'm trying to tell you. What type of projects may be financed? Municipalities may issue general obligation bonds for a municipal purpose authorized by a charter or Missouri law. So that means that you don't have to be a Missouri charter. You do not have to have a city or municipality in order to use Missouri law to raise finance bonds. Okay, and that means that you can even register. You can have unregistered securities in order to solicit those bonds to be financed by the taxpayers. What is the source of funds for repayment? General obligation bonds are secured by the full faith and credit, and that means if the people basically acknowledge, which they never passed the totem around to petition whether or not you want your full faith and credit animated and then used to borrow money or the taxing power of the municipality, which follows, the basis of that is that the source of the repayment is funds that are already secured by monetizational policies backed by what the city says it has in assets. So that means that your property is considered an asset of the city, especially if they're taxing you per a code to indulge the financial graft of paying back these bonds. And as it follows, it says, this means that a court can compel the municipality to increase tax properties if needed to repay the bonds. The owner of the general obligation bond may look for repayment to all legal available sources of revenue that the municipality is entitled to receive. Okay, we're going to continue here. And this is it kind of gets a little iffy here. And as far as the language is concerned, I don't want to lose anybody on this. Section 26F of the Missouri Constitution is Section 95.135. Revised Missouri statutes require that before issuing general obligation bonds, a municipality must provide for the levy of an annual property tax that will be sufficient to pay the principal and interest on the bonds. They only pay interest, not principal. To satisfy this requirement, the levy will be included in the ordinance authorizing the issuance of the bonds. So basically, the levy of which included your property is in an ordinance authorized to issue the bonds against. So it's kind of like saying we have an ordinance that is passed to secure your property as part of the annexing of finance. Okay, so that means if we have a contract saying we're going to annex $5,000 of your debt that you owe this year coming due, then the obligation to pay that is based on the securitization of your property. Of course, the city, if you call the city and ask them, do they own your property, or do they have a levy on your property? They will say no. But the issuance of these bonds, authorizing the issuance of the bonds, and the requirement of the levy in the ordinance authorizing it says different. Now that's kind of funny, isn't it? The municipality may use other revenue sources, such as sales tax proceeds, to pay debt service on the bonds, in which case the property tax levy may be unnecessary, and municipalities may choose not to collect tax in that particular year. So, excuse me. Excuse me. The limitations here. What are the limitations of issuing general obligation bonds? New money bonds. Article 6, Section 26 of the Missouri Constitution governs the amount of general obligation bonds that may be issued by the city. The debt limit is tested at the time of the election of the election to authorize the issuance of the bonds. It goes on and on and on as far as how the assessment of the valuation of property, sewer, street and sewer improvements, and so on and so forth. I mean, it goes on and on and on. All right, as far as how they've invented ways to create their underlying funding processes. I'll kind of outline it here, and you can go ahead and take a read on it. All right, matter of fact, I'll just leave it as so and just kind of outline the top half and just let you go ahead and read, and I'll move on. All right. Now, of course, you can stop and review this as you see fit. Not a problem, so that you get a good idea what's going on here. Now, what are voter approval requirements? Now, in general, they don't usually put what is called a form ballot. Now, this is what I found, and this is how I was able to find the statute itself. I actually took it, I looked it up, it gave me a search, I went straight to the ballot, boom, and this is what it is. Exactly what I read in the first section of this video. All right, the question should be submitted, and they then basically ask the public, hey, how should we raise money? In reality, they usually do it through statutes, and that is based on them putting together a relatively simple regiment of language-bearing exchanges, which is their means to kind of categorize the way the public should see something fit when they are making their declaration to campaign finance and things of this nature, in their language, that is. So the form of the ballot, which of course this entity here is telling them how it should be done. Gilmore and Bell, very important. Gilmore and Bell is showing them how this form of ballot should be done. Of course, it's subscribed probably in the ballot, not the ballot, but the election of a bond to be prescribed in the first place. But they probably don't do it in a questionnaire, only inside of the minutes of the recordings. So it's probably not done in open verbatim language, and it definitely wouldn't want to do that, knowing that someone could say whether or not if they say shall the city of blah 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 issued the bonds in such amount of dollars for the purpose of, and you say, oh, wait a minute, I got a question. Since that is a question mark, there's a question mark. Can I validate whether or not my taxes should be in that particular bond question, in which is submitted for the purpose of electing me, the taxpayer, to pay for something you're borrowing against? So here is the prescribed form in question in the statute, which says does not include the bracket words general obligations. Why? Because though the practice is recommended to clarify the nature of the bonds being voted upon. So that means it does not. That means they can hide You see, it says in the statute, the words general obligation. That means that they're saying they do not have to specify the source of why they are electing to have it recommended, even though it is recommended to clarify the nature of the bonds being voted upon. So it's kind of like saying we don't necessarily have to tell them, but we don't have to prescribe it by the language. Therefore, no one really knows what we're actually voting on. So when it says they're asking themselves. If it said shall general obligation bonds or something of that nature, or general obligation issuance of it says here, even though it says it here, they put a different language. Okay. If it said shall the general obligation party, which then would follow with the name, issue, bonds in the amount of, if they did something like that, then they would be negotiating for you directly. See, for you not to hear that means that they're negotiating. You see here, it says shall the city, not your name, not the general public, as in the general obligation party, us, i.e. I'm a party to the contract. Contrary to belief, this is the way to subscribe you out of the language, which is then reinterpreted as the city instead of you, okay, or we, or us, or some of that nature. Have you ever seen a contract where it says I, we, us? They're actually saying that we are a part of the application. It says the prescribed form of the question in the statute does not include and it goes down here. I'm going to move down a little bit. The bond question should not include any language stating the repayment of the bonds intended to be made only from the particular funding source, like sales tax, or that property tax levy for repayment of the bonds is in any way limited it. Okay, let's read that again. The bond question should not include any language stating the repayment of the bonds is intended to be made only from the particular funding source. So that means that after they make the bond out, the funding source then can prescribe tax levies and things of this nature, and they only do that through the commercialism between them and the buyer of the bonds. So they don't have to clarify where the source of the funds are going to come from, because the city's then going to say, hey, let's raise taxes here, here, and here. We're going to ask why. And they're going to say, well, the question is can we pay our investments back? In other words, let's duck the question of where the sales tax or the property tax levy was supposed to be, because it was supposed to be subscribed in the language, but it's an entitlement that has to be repaid back simply because there's no limitation for the language to be exposed, or neither should we specify how that language should be used when distorted by a statute, which is the distortion of a statute is to otherwise say something that doesn't say the actual words or say the verbiage verbatim, just like general obligations. So that does not have to be specified because the statute doesn't recommend that it put it in it, even though it does recommend, though this practice, it says very clearly, though this practice is recommended to clarify the nature of the bonds being voted upon, meaning we can be deceptive, but we don't necessarily have to show that the deception is by legal acquiescence of answering you. And the only way we would answer you is if you could show us in the statute general obligation or general obligation bonds or some of that nature does not have to be in the actual language of the bond or any contract submitted to be public knowledge for these bonds to be paid back, giving them practically no limitation to language, annexing language any way they see fit. It's bananas. This thing is crazy. Anyhow, I'd like to get further into this, but I'm just gonna end it with this is how they pay. This is how your money comes out of your pocket and enters into theirs. You see? And it's ridiculous. I mean, it's not ridiculous as in what they're spent on, but because most of these monies do not make it to these particular sections and acts that are used to fundraise in the first place, it's just really a nice farce that they put up. Okay? It says sales tax available to municipalities upon receiving the required voter approval, that is us. The following sales tax are available to municipalities under current law. Here's your current law. Here's your authority, which the revised Missouri statutes allows these sections to be used to collect monies for these particular activities. You see, capital improvements, community center, community centers for children, convention and tourism, economical development, and some of them are for other cities, but some are just for general purposes, of course, general purposes, all municipalities, like for instance, St. Louis County, hotels. I mean, and this is improvement. This is to improve a hotel, to keep the upkeep, that they're statutorily asking for that money and they're getting it. Okay, what else do we have here? We have motels, hotels, bed and breakfast inns, campgrounds, docking facilities used by transients for sleeping. Transient guests includes all these entities that would be fostering these people that want to be in those particular facilities. Hotels, motels, bed and breakfast inns, campgrounds, and docking facilities used by the transients for sleeping. That's St. Joseph's, and then it goes on and on and on. It's bananas. Mass transit. You got medical indigents, museum and tourism, museum and local option museums, parks and local parks and stormwater control. I mean, you name it, they got something to do with it in some way, shape, form, or fashion. Tourism, transportation. Kansas City, like you've seen those transit, like in Chicago, I used to see the buses that would drive around Al Capone's territory. They call it the Big Al's bus, and the bus was paid with taxpayer money. And so you got transportation. So they're codifying it. Then someone goes down, asks for the money. They get a grant for it. They got a bus. Then they fuel themselves up because the state or the city or municipality has taxed us to allow them to go around and have fun. Looking at old owls hangouts, who got killed, who got popped, who got shot. February 14th when he did the massacre on the near north side. All kind of things, but these are based on benefits that are coming out of your pocket, and the private sector is beginning to pocket graves amount of huge rewards and incentives for, as you can see down here, it says in the development of business deals. Such agreements should be drafted by legal counsel and close consultation with municipal officials to ensure that the action promised by the municipality are within the municipality's power and that the terms of the agreement correspond to the business deal agreed to with the developer. So you're talking about outside exchanges where it's kind of just, it's open grounds for using your money for whatever particular purpose that they can use as an economical incentive, and that's what they call it. Awards of economical development incentives often involve entering into a public-private partnership. So it's kind of like saying we give you incentives for being good taxpayers, when in reality the people that are really paying the taxes are people that are downtrodden, used, and abused for being a part of the tax bracket in the first place. And usually the less you make, the more taxes you pay. So you know who's really not benefiting from it. Anyway, this is Politics and Money. You already know how to get a hold of me. Professor Phil at 424-245-9408. Or email is PROFPHIL at politicsandmoneyinc.com. Website is www.politicsandmoneyinc.com. That's politics, politicsandmoneyinc.com. Anyway, I hope I gave you a wealth of information. You already know what time it is. I'm out. Peace.